Hello and welcome back to Chapter 9. This is just a brief review of the first three sections of Chapter 9, starting on page 169 and 170. So remember your purposes for your health record, and then looking over at page 171, getting into the legal health record. Know what the definition of your legal health record is. It is the business record that is disclosed upon request. So don't forget that. Be sure, just go through these slides, know what's in a designated record set versus a legal health record. Mostly just knowing that your designated record set is a more broad range of documentation than your legal health record, because your designated record set's going to include information such as insurance enrollment and their coverage, and billing information, things like that. So know your differences in your paper versus electronic health records. So we talked about how large volume and ease of duplication in electronic it's so much easier to duplicate an electronic health record. You just print it right out and you've got a copy. Persistence. Electronic documentation is much harder to get rid of. You can burn paper, you can shred paper. You think you've deleted an electronic document, but it's still hiding there in the background. Again, metadata applies to electronic health records. You know who looked at a document. You know who modified a document. You know who printed a document. You don't necessarily know that looking at a sheet of paper. Then the automatic updates, obsolescence. If your program is no longer in date, you may not be able to view things. And then searchable. It's easier to use that Control F function to find information within an electronic health record compared to paper, where you would actually have to read each piece of paper to find what you're looking for. All right, we get into the Uniform Photographic Copies in Business and Public Records as Evidence Act. That's over on page 174. So this states that the reproduction of any record retained in the regular course of business and kept by a process that accurately reproduces the original in any medium is just as admissible as the original when submitted as evidence in judicial and administrative proceedings. So this is what allows us to actually make a copy of an electronic health record to submit it as evidence into court. All right, moving on into where we started with content, documentation, and actual maintenance of the record over on 175. We talked about how there are federal laws such as Medicare's conditions of participation. You have state laws, and then of course you have accreditation standards, Joint Commission being one of the bigger ones. Your professional guidelines coming from the AHIMA, and you have some professional guidelines back there. Actually, you have their AHIMA's content of the health record in 9.4. And let's see, what else do I want to cover? Okay, getting into who should document, how they should document, what kind of language. Be familiar with the language that should be used versus language that shouldn't be used. Patient doing well just doesn't suffice. Confused, stable, as usual. Those words should not be used. Author needs to be specific, objective, and factual. All right, going down, who may not document. HIM is not going to document in the record. So there's going to be information in our policies and procedures within your medical staff bylaws as who can document in the record. Be familiar with what gaps and omissions are. You can have a physical gap, or you can have a gap in time, or you could have information that's just not documented that could be an omission. All right, back to our physician orders, starting on page 178, going through 179. We talked about two types of orders. You have written and verbal. Written, just what they are. Physician handwrites an order. And then a verbal. They could literally be standing right next to the nurse and give the nurse the order, and the nurse enters it into the computer system, or they call the nursing station and tell the nurse the order over the phone. Now, while this helped with illegibility, sometimes people say things and they may not necessarily have meant to say. So it's very important that you do that read back. So whatever staff position that can take that order, because not everybody can take an order. I could be on the nursing unit and have to answer a phone, but I'm not able to take that order from that physician. So whoever is in charge of taking that order, they should read back the order as they have entered it to that physician to ensure that it is correct. Let's talk about hostile patients. How are we going to document about our hostile patients? Well, first of all, we still have to remain objective. We state the facts. We do not put our personal opinions in the record, especially if we're trying to be critical of the patient. That's a no-no. Also, staff disagreements. Do not argue or fight in a medical record. Okay? There can be differing opinions, and they must be documented in the record if they're pertinent to care. But you should not make it known to anybody reading that record that you are fighting with another physician or you are fighting with another nurse. Again, language must be objective and factual. All right, documentation principles continued. We're going back over onto page 180. We talked about how there is documentation from criminal injuries or criminal activity. So if someone comes into the ER and they've been stabbed or they've been shot, then that must be documented, and there's some details in that paragraph of what should be documented, and also that it should be shared with local police officers, the local PD. And also there are certain populations of people, if there is suspected abuse, those should also be reported as well. And those populations are listed there in that first paragraph under documentation of injuries resulting from criminal activity. So again, we're talking about children, elderly, and individuals with developmental disabilities. Those are your protected populations. And then liability for improper injuries. That last little section there in that first section is talking about how missing or incomplete information may lead a court to instruct the jury that it may infer negligence. So you want to ensure that everything that happened is charted, it's not biased, it's not critical, and it is based on fact. All right, moving into that second section, we get into our legally defensible record. We talked about data governance and information governance, and then we get into authenticity, where we broke down authentication, which is the security process that verifies my authority to be in the system. So that's my login ID. And then the attestation, that's actually applying my signature and showing ownership to a documentation. Continuing on, we have the Uniform Electronic Transaction Act over on page 183. Wait, I'm sorry. Not on 183. Where's it at? That's e-sign. Is the other one okay? Yes, okay. They are both on 183. Sorry, I didn't see it. I had it highlighted. So the Uniform Electronic Transaction Act, this is electronic records and signatures are legally equivalent to paper records and handwritten signatures. So basically saying that if we sign something electronically, it's just like us signing it on a piece of paper. And then you have e-sign, the Electronic Signatures in Global and National Commerce Act. This validates electronic records and signatures to be legally recognized for interstate and foreign commerce. All right, then we get into, and we didn't really talk about the digitized and the digital signatures, but be sure to read through that section as well. You could have some questions there about those on your test. But back to our attestation issues. So first of all, we have counter signature issues. Remember, this is where you have like that resident or that medical student. They can complete the documentation, but they're going to have that attending physician come behind them and sign off behind them. And when they sign off behind them, it talks about how they are basically taking responsibility for that document at that time. So when they've put their name on that signature, it now becomes theirs, even though it was created by the resident or the medical student. Okay, we talked about multiple attestations. That was like our nursing worksheets, where one worksheet might be used for a 24-hour time period. So, like, think about input or intake and output. And so you may have 3 different nurses or 2 different nurses documenting for that 24-hour time period. And so they may have a section for initials, and then there may be a section at the bottom for their full name. All right, then when you have attestation on behalf of another, we talked about this when we mentioned that if a physician leaves and they do not return to the facility and they've left documentation unsigned, you may have someone that was also a part of that case sign off on that document for them, or in some cases you may have to do some kind of administrative sign off. Auto attestation, this was when we talked about how technically, if they didn't even read the document for, let's say, the time period of 24 hours, it would just automatically apply their signature. Well, we also talked about how with Medicare and Joint Commission, they do not permit auto attestation because they require that specific action from that physician or nurse practitioner, physician assistant, whoever, to attest to that document entry. So there's something that has to be physically done, whether it's just pressing a button to apply that signature or clicking on a box and applying that signature. Something has to happen. Okay, we talked about batch signing. This is where they can actually sign off on 500 orders at one time. There were a few caveats there. Each one had to be able to be acted upon individually, and then you had to be able to remove them from the batch. And of course, you had to be able to see all of them. So as long as that criteria was met, then it could be considered a batch signing, and they could go ahead and sign off on all of those. Okay, our last one was scribes. We talked about these being people that actually kind of trail that physician around, and maybe that physician is examining the patient and that scribe is sitting at the computer, and the physician may be spouting off documentation, and that scribe is actually entering it into the chart. They should document that it was entered by a scribe, and then it does have to be countersigned by that physician. All right, now we're getting into, again, the integrity, that last little section there. In the section 2, we're talking about metadata. So, of course, this provides the background information on actions that can affect creation, revision, and access. And there we talked about our templates and how sometimes they do create integrity issues because not every patient is cookie cutter and not every template is going to fit every single diagnosis because there is other conditions and other things going on with those patients. All right, let's look at, well, that actually covered all 3 of those sections, so I think we're good. Again, just read through this chapter. I'm going to give you some extra time since we did not meet face-to-face and go through this chapter, the last 3 sections, so we're not going to test until Monday. You'll have until 11:59 p.m. to complete that. That will be your attendance for the day. So again, just read through this section, go back through your review questions, and then good luck on your test on Monday. See you later.